A landmark decision in Oklahoma. A judge finds Johnson&Johnson played a substantial role in that state's devastating opioid crisis. Now, for the first time, a pharmaceutical company is being held accountable for what is one of the worst health epidemics in history. And here was that key moment.
The opioid crisis is an imminent danger and menace to Oklahomans. My judgment includes findings of fact and conclusions of law that the state met its burden, that the defendants, Janssen and Johnson&Johnson's misleading marketing and promotion of opioids created a nuisance as defined by 50 OS Section 1, including a finding that those actions compromised the health and safety of thousands of Oklahomans. Specifically, defendants caused an opioid crisis that is evidenced by increased rates of addiction, overdose deaths, and neonatal abstinence syndrome in Oklahoma. This is a temporary public nuisance that can be abated, and the proper remedy for public nuisance is equitable abatement. As I just stated, the opioid crisis has ravaged the state of Oklahoma. It must be abated immediately. For this reason, I am entering an abatement plan that consists of costs totaling $572,102,028.
This is really a landmark decision, and this is going to be studied in states across the country. There are dozens of states working to sue Big Pharma for the role that they say that those companies play in fueling the opioid epidemic that has killed hundreds of thousands of people in the last 20 years. Success for the state of Oklahoma, the first state to take a big pharmaceutical company to trial making those allegations. They claimed that Johnson&Johnson had created a public nuisance, one that cost the state billions of dollars and claimed thousands of lives. After 8 weeks of testimony, more than 100 witnesses, the judge said that the state had met its burden. Now, Erica, the state was seeking some $17.2 billion worth of abatement that would go toward programs within the state for prevention and treatment, other addiction services too. The judge in the end ordered $572 million, still a big number, not what the state was looking for. Not clear how exactly the judge came up with that number. He says if more money needs to be allocated to the crisis, it's something that legislators will have to take up.
From WBRN Radio and on the Boston Red Network. Our episode today is the state of Oklahoma versus Johnson&Johnson. That trial concluded in Norman, Oklahoma, Monday. Today's date is the 27th of August, 2019. This is a very interesting trial, and we'll actually go into the opinion of the judge. We feel this is the only true and proven presentation of model. This in itself will bring out certain things that are not presented in the at-large media. Simple reason they don't have the time. And then we'll have some commentary. We'll read from the actual opinion of the judge. But we'll set this up with the local newspaper, the Norman Transcript. Dateline Norman, Oklahoma, and I'll read this. A New Jersey-based pharmaceutical company caused an Oklahoma opioid crisis that led to thousands of deaths and must pay $572.1 million to fix it. That in a Cleveland County, Oklahoma district judge ruled on Monday. The judge, Thad Balkman, told a packed courtroom that the opioid crisis is an immense danger and a menace to Oklahomans, and the state proved that Johnson&Johnson, its subsidiary Janssen, launched a misleading marketing campaign that created a public nuisance in Oklahoma. The amount awarded, though, was well short of the state actually asked there for $17.5 billion. Was seeking to abate the crisis over 30 years. And in the ruling, and we'll get to the ruling here in a minute, said the state failed to prove the amount of time and cost necessary to abate the problem beyond 1 year. He said the state could use the opioid award to pay its attorneys. Johnson&Johnson said they will appeal. They will appeal to the Oklahoma Supreme Court. Sabrina Strong, she's been on various media, said her side is disappointed and disagrees with the decision. Naturally, there. We believe it's flawed, she said. We have sympathy for all those who suffered from substance abuse, but Johnson&Johnson did not cause the opioid abuse crisis in Oklahoma or anywhere else in this country. We do not believe that the facts are the law supports the decision today. We have had many strong grounds. Many strong grounds for appeal, and we intend to pursue it vigorously. Well, they will have to file a notice of appeal, and we'll see how that works out. In a statement, the company said the ruling disregarded its compliance with, and this is a key here, federal and state laws, unique roles in the medication plays in the lives of those who need them, and then its responsible marketing practices. The company said its medication accounted for less than 1% of the total opioid prescriptions in Oklahoma. The Attorney General there, Mike Hunter, called the verdict a major victory for anyone who has lost someone to an overdose. Johnson&Johnson will finally be held accountable for thousands of deaths, addiction caused by activities. He said, throughout the trial, our team proved that we have alleged all along the company used pseudoscience. In other words, that's made-up science, misleading information to downplay the risks of opioids and leading to the worst man-made public nuisance the state and our country has ever seen. The verdict marks the conclusion of the first opioid trial in the nation. The nation is now facing thousands of lawsuits from states, tribal governments, and local governments. The state previously settled with Oxycontin, Purdue Pharma, Teva Pharmaceuticals, $350 million. In the rule, he noted, this is Blackman, from 2011 to 2015, more than 2,100 Oklahomans died from accidental prescription overdoses. In 2015, more than 326 million pills were dispensed to Oklahoma residents. That's enough, he wrote, for every Oklahoman to have enough to have 110 pills outside of the courthouse. Craig Box said he needed to read the verdict to fully understand it. Box, an attorney from Enid, testified during the 8-month trial about his son. The 22-year-old University of Oklahoma linebacker had 5 pain killer prescription in his system when he died of an accidental overdose. That was in 2011. I'm just pleased that the court found that Johnson&Johnson was responsible for this epidemic that caused so much pain to Oklahoma. So this is very interesting here. We'll go now. Well, let's go to the New York Times. We did it locally. And many newspapers have written on this and the verdict of it pursued here. And we'll just the headline from the Times. Each news outlet has a little different situation going on here. This is by Jan Hoffman, writing on the 26th of August, 2019. A judge in Oklahoma on Monday ruled against Johnson&Johnson. The deep-pocketed corporate giant ordered it to pay $572 million in the first trial of an opioid manufacturer for the destruction wronged by a prescription painkiller. Johnson&Johnson contract with poppy growers in Tasmania supplied 60% of the opioid ingredients. And this is very important. They supplied the ingredients used for opioids like Oxycontin. The state had argued and aggressively marketed the opioids to doctors, patients as safe and effective. A Johnson&Johnson subsidiary, Janssen Pharmaceuticals, made its own opioid pill, rights it sold in 2015. Fentanyl, a patch that is still a product there. And remember, fentanyl was the opioid involved in the death of the Inatina Prince that took it from a bottle that was mislabeled. The drug maker was the landmark ruling was a resounding victory for the Attorney General Mike Hunter. The closely watched case could be a dire warning for some 24 opioid makers, distributors, and retailers that face more than 2,000 similar lawsuits around the country. Not a good day for them. We've shown that J&J was at the root cause of this opioid crisis. This is from the judge there. This is Brad Beckworth, the lead attorney for the state. Now, these are outside counsels. It made millions of dollars over the 20-year period. They always deny responsibility, yet at the same time they say they want to make a difference in solving the problem. So these are some of the Purdue Pharma and Teva Pharmaceuticals settled with Oklahoma earlier in the year for $270 million and $85 million respect. In doing so, the companies did not admit wrongdoing. As a consequence, Oklahoma faced a steep climb of pinning the blame for its crisis mainly on one defendant, that's Johnson&Johnson. In December, a jury trial in St. Louis, Missouri, found Johnson&Johnson, which had sales of $81.6 billion last year, should pay $4.7 billion because of its talcum-based baby powder that caused cancer there. So they're in courts all over the place. In a statement, Michael Altman, the General Counsel, Executive Vice President of Johnson&Johnson, said Janssen did not cause the opioid epidemic in Oklahoma. Neither the fact nor the law support this outcome. We recognize the opioid crisis is a tremendously complex public issue. Janssen is one of the largest manufacturers of name-brand drugs in the U.S., reported sales of $23.3 billion in the U.S. Oklahoma has suffered mightily from opioids. 2015-2018, 18 million opioid prescriptions were written in a state with a population of only 3.9 million. Since 2000, his office said about 6,000 Oklahomans had died from overdoses, with thousands more struggling with addiction. Now, this is in Oklahoma here, and this is some of the anecdotal information here. Let's go back to the opinion itself, and we'll just have to scan it. We read it earlier here. The title of the case is State of Oklahoma LOT. Mike Hunter, Attorney General of Oklahoma, is the plaintiff, and the various defendants here, there are a lot of them, including the barcode. Purdue Pharma, LP, Purdue Pharma Incorporated, Purdue Frederick Company, etc., Johnson&Johnson, Janssen Pharmaceuticals. We'll just hit the highlights of some of those. Watson Laboratories, Inc., etc. Those were the defendants here. Judgment after it's a non-jury trial. Incidentally, they decided, Johnson&Johnson, to not risk having a jury trial in a very red state. The late great Jerry Pippin, our broadcast partner, would be very proud of what happened here in a conservative state. The judge here was a conservative type, it appeared. He was also a member of the Latter-day Saints, the Mormons, out of Utah, which is a little bit unusual for the Baptist belt there, but this sort of set some things in motion. Had we at this mic been involved in the particular case, I would have been a bit leery of taking a case before him. But normally what happens is, if you feel that a jury would obviously find against you, and the judge would know the appropriate law. Anyway, let me start with the caption of the case beginning in the 28th of May, 2019. That's when the trial started, and it ended on the 15th of July. The court conducted a non-jury trial in the above captioned matter. From the time this action was commenced, that was on the 30th of June 2017, and through and including today, this court has been a beneficiary of extraordinary professionalism and legal work on the part of counsel effectively for each party. I am abbreviating some of the wording here because of the time duration. The introduction, the sole claim for relief against the defendants was for causing a public nuisance pursuant to Oklahoma statute 51 in sequence there. The state sought relief in the form of abatement of a nuisance. The defendant sought no counterclaim at trial, and contend the state failed to meet its burden. And incidentally, this is a tort action. The defendant, in addition, the defendants asserted multiple theories of defense under both statutory and common law. Over the course of 33-day trial, the parties called 42 witnesses, submitted 874 exhibits into evidence, and presented an additional 250 court exhibits. The parties agreed Oklahoma is suffering a crisis related to opioid drugs. The parties agreed on certain statistics and called stipulations and data sustaining the crisis. The parties agreed that from 1994 to 2006, prescription opioid sales increased fourfold, and from 2011-2015, more than 2,100 Oklahomans died of unintentional prescription opioid overdoses. It was undisputed that in 2015, 326 million opioid pills were dispensed to Oklahoma residents, enough for every adult to have 110 pills. Oklahoma dispensed the most prescriptions for fentanyl per capita in 2017. 4.2 babies covered by Sunicare, that is their Medicaid, were born with neonatal absentia syndrome. When a baby withdraws from certain drugs, the leadership of the Oklahoma Department of Mental Health and Substance Abuse Services, as well as other agents pursuant to a grant awarded in 2008, that department conducted a statewide assessment that identified the prevention of underage drinking and prescription drugs as two of the most pressing issues facing the state. In 2012, it formed a prescription drug working group, that is, the state of Oklahoma did. And in March 2017, DJ Trump established the President's Commission on Combating Drug Addiction Opioid Crisis. The commission studied ways to combat and treat drug abuse. Finding of fact: to the extent any evidence in the record conflicts of one of the facts found below, the court has weighed the competing evidence and found the greatest weighted evidence weighed in favor of the facts set forth below. The state of Oklahoma and the public in general are currently experiencing an opioid crisis. 2. The current crisis, the opioid crisis, was started by and still primarily involves prescription opioids. Through the mid-1990s, there was no opioid, and he does some cites here. I won't go into those. 4. Since at least the mid-90s, defendants have marketed, promoted, and sold opioid drugs in Oklahoma. During this time, defendants specifically manufactured and sold their own branded opioid drugs as a part of pain franchise. Now you'll hear this in a patch called Dargestic. I hope that's how I pronounce it. If I mispronounce it, I did. And the ingredients for fennel here, and various other things that they made. In other words, they made the basic ingredients that went into many of these opioids. Now, number 5, Paul Janssen. Dr. Paul Janssen originally invented the 1950s, and so forth and so on. Schedule 2 opioids comprised of fentanyl. Did I say fentanyl? The defendant's Dargestic was had the highest potential for abuse, and some of the Tasmanian things. This is the raw ingredients to those. Up until 2016, Johnson&Johnson sold its Tasmanian alkaloid business, and they give a little evidence. Narco workers were with Johnson&Johnson. For the workers simultaneously held positions at multiple companies within the Johnson&Johnson family of companies. And in fact, they use some of the same banks who want 8 defendants through their subsidiaries supplied the following opioid APIs to other drug manufacturers, including Purdue and Teva, Oxycontin, and various others: morphine, codeine, fentanyl, hypomorphine. Anyway, we won't go into all these characters. In 1980, Johnson&Johnson acquired and formed the Tasmanian Narco in order to ensure a reliable supply of raw materials. Now, they had the raw materials going there. Located in the U.S., imported the narcotic raw materials produced by Tasmania into the U.S. They owned all these subsidiaries in order to secure security of supply, direct access to the raw narcotics. In 1994, the defendants, in concert with their subsidiaries, anticipated demand for Oxy 12. The defendants anticipated opioid demand by selling the API, including Oxycontin, to Purdue, and this is the chain of death here, so to speak, how it was done. And they proved here that they acted in concert here with these other manufacturers. This is usually always part of the burden of proof. Defendants, corporate representatives were not aware of any training provided to defendants' sales force in Oklahoma on the disease of addiction. Nor was defendant corporate representatives aware of any training provided to the sales force related to the history of opioid use and the epidemic in the U.S. and human training. It does go to, as part of the same training, defendant trained sales representatives to establish that moderate to severe acute continue to be undertreated. Now, that's defendants particularly targeted primary physicians with opioid marketing, identified them as key customers. Defendants Oklahoma's call note documented that sales reps distributed visual aids citing Allen Simpson and Mulligan studies thousands of times. These were studies primarily paid for by the opioid manufacturers. You hear this throughout. Defendants did not train their sales reps regarding red flags that could indicate a pain mill, including, for example, pain clinics with patients lined up at the door, or patients passing out in waiting rooms. Oh boy. Marketing strategy developed for defendant sales force, including utilizing, this is usually the scam, a coupon program as a marketing tool. This is for some sample vouchers in which sales reps delivered to a physician a sample voucher for boxes of 25, 50 milligram patches. These were the patches, Dargestic patches. I hope I'm pronouncing that right. Sales reps called on Oklahoma medical professions hundreds of thousands of times while selling their opioids, as evidenced by 35 boxes of call notes from the defendants. Defendants made substantial payments of money to various different pain advocacy groups, including but not limited to the American Academy of Pain Medicine, the American Pain Foundation, American Chronic Pain Association, the American Society of Pain Management Nursing, and it just goes on and on and on. Two organizations defendant-funded issued consensus statement as in 1996 that was drafted by a committee that included Robert Angarola, an attorney who at the time represented defendants in opioid-related issues. Specifically, the consensus statement was written by the committee, including a former Dr. Haddox at Purdue Pharma. And some of these people had financial relationships with them, not unusual. Wait on my pointer to refresh itself. And this whole thing about misleading claims, let me get some of the more cogent parts of how these characters actually did this and how the nuisance was applied. These supplementary addiction treatment services, including housing services, employment services, additional juvenile services. Now, these are some of the things that were established here. Let me just... This was by the American Society of Addiction Medicine here. And here they talk about the total cost for these services in 2019 dollars of $31,796,000 there, and the commissioner involved there, and the various. In other words, it's an itemized statement, remembering that, noting that this is a 1 year a cost to the state of Minnesota. Let me go up just a little bit here, because what we want to set up is how they were able to do this public nuisance in the state of Oklahoma, involving driving on highways, roadways, the use of computers, smartphones, etc. to contact people. Now, this is a nuisance, consists unlawfully doing an act or omitting to perform a duty which act or omits either annoys, injured, endangers the comfort, repose, health, and safety of others. That's the first element. Offends decency, or third, the unlawful interference with the obstruction and tendency to obstruct or render dangerous for passage of any lake, navigation, river, stream, canal, basin, public park, street, or highway. In any way render other persons insecure in their life. And this is the clue here: the use of in the use of their property, provided this section shall not apply to any pre-existing agricultural activities. Anyways, the old statute states, this is Oklahoma 5th section 2 here, states that a public nuisance is one which affects at the same time an entire community or neighborhood or any considerable numbers of people, and to the extent of the annoyance or damage inflicted upon individuals may be unequal. The plain text of the statute does not limit the public nuisance to those affected by property. Unlike other states' statutes that limit nuisance to habitational use of threats or contemplated habitational use of any place, Oklahoma statute simply says unlawfully doing an act or admitting to perform a duty. Now, remembering that this is written in the early 1900s, and Oklahoma at one time had a socialist flag. So you can understand what is going on here. He goes on to cite the judge that is several later cases. Cox versus State, Oklahoma Department of Human Services, 2004. This court does not read exceptions into the statute, nor may we impose any requirements not mandated by the legislature. Now, the Supreme Court President also supports inclusion that Oklahoma's nuisance law extends beyond the regulation of real property and imposes the corporate activity complained herewith in. And the judge cites section of 450 revised law 1910, defining a nuisance to be an act with annoyance, injury, or endanger the comfort, rapport, etc. We just read that. And in 1921, he cites Epps versus Ellison. Now, this is one thing very important. With some of these states, it would depend on where they were at a particular time in history. Thus, the term nuisance signifies in law such as the use of such a course of conduct, irrespective of actual trespass against others, are of malicious or actual criminal intent, which transgresses the just restrictions upon use and conduct, which the proximity of other persons and property. However, in the alternative events in Oklahoma's nuisance law does require the use of property, the state has sufficiently shown defendants pervasively, systematically, and substantively use real and personal property, private and public, as well as, this is where we get to roadways, buildings, lands, the state of Oklahoma to create a nuisance. Defendants did not attempt to dispute that defendants' sales representatives were trained in their Oklahoma homes to spread defendants' marketing messages. They conducted their deceptive marketing and sales efforts in doctors' offices, hospitals, restaurants, and other venues. They used company cars, and this is to travel on state and county roads to disseminate misleading messages. Defendants paid speakers to deliver defendants' message to doctors in the Oklahoma offices. And they cite some cases here, Dean versus Eshman, and etc. here. And anyway, defendants sent their message into homes of thousands of Oklahomans via computers, smartphones, and other devices. And then again, the Dean Escherman case is cited here, all of which involve the use of property, real, personal, to create and exacerbate a public nuisance. This is where they have nailed them down. The exception in this law, the challenge conduct is defendants' misleading marketing and promotion of opioids. The states claim that defendants engaged in false, misleading, deceptive marketing campaign designed to convince Oklahoma doctors, patients, and the public at large that opioids were safe and effective for long-term treatment of chronic non-malignant pain, because a lot of these drugs were originally used in treating cancer. Defendants promoted their Pacific opioids using misleading campaigns. Among other things, they sent sales reps into doctors' offices to deliver misleading messages. They disseminated misleading pamphlets, coupons of printed materials for patients and doctors. They misleadingly advertise their drugs over the internet. Now, this is where the internet comes in, all of which occurred here in Oklahoma. But the defendants also pervasively promoted the use of opioids. Generally, the unbranded marketing material included, like print material that misleadingly taunted the safety and effects of opioids as a class of pain medication, as well as online material promoting opioids in general. Defendants used and viewed medical events, including Speakers Bureau, continuing education opportunities, and promoting endeavors that defendants leveraged to increase marketing for opioids through misleading messages. And according to defendants, this is Johnson&Johnson here, and others, the internal training documents, defendants conceded that the false and misleading promotions include at least the following types of conduct: broadening the product's indication, data taken out of contents, minimization of safe issues, omission of internal information, that usually gets them every time, comparative efficacy of or safety claims without substantiating evidence. Based upon my findings, the defendants' false and misleading and dangerous marketing campaigns have caused increasing rates of addiction, exponentially increasing, and overdose, national absentia syndrome. I conclude these are unlawful acts which annoy, injure, and endanger the comfort, repose, safety, health, and safety of others. 10. The facts show that defendants engaged in false and misleading marketing both of their drugs and opioids in general. And the law clearly makes that conduct is more than enough to serve as an act or omission necessary to establish the first element of Oklahoma's public nuisance law. Accordingly, based upon the foregoing, I conclude defendants engaged in false and misleading marketing both of their drugs and opioids in general, and this conduct constitute a public nuisance on the extent of Oklahoma law. The First Amendment to the Constitution does not prohibit imposing liability for acts complained here. The First Amendment rights may not be used as a means or a pretext for achieving subsidiary evil, which legislation has the power to control. That is California Motor Corporation versus Trucking, 404 U.S. 508, etc. The fact of dissemination of information and opioid on questions of public concern is ordinarily a legitimate and protected and indeed cherished activity. Does not mean, however, that one may in all respects carry out these activities exempt from sanctions designed to safeguard legitimate interests of others. Federal security regulations, mail fraud statutes, common law and action for deceit and misrepresentation are only examples of our understanding the right to communicate information to the public that is not unconditional. Moreover, the Supreme Court President recognizes common sense distinction between speech purporting commercial transaction, i.e. commercial speech, which occurs in an area traditionally subject to government regulations, and variations of speech. And then again he cites this understanding the First Amendment has led the Supreme Court to consistently emphasize that other forms of commercial speech regulations are surely permissible, including restrictions on false, deceptive, and misleading commercial speech. And he cites here Virginia State Board of Pharmacy versus Virginia Citizen Consumer Council. That was in 1976. On truthful speech, commercial or otherwise, has never been protected for its own sake. Bates versus Bar of Arizona. Advertising that is false, deceptive, and misleading, of course, is subject to restraint. And I'm going to finish this up. To his last sentence, we'll go to it. 42. Our comments here is that this lawsuit, in our opinion, we made reference in one of the episodes to it, and we felt because of the judge, the atmosphere they have, that Johnson&Johnson was fighting a losing battle that they should have not been in the first place. The court concludes that pursuant to the agreement between the state and its outside counsel governing the Oklahoma action, outside counsel is expressly entitled to collect attorney's fees for the abatement process as a result of this judgment. This is 60. Outside counsel entitled to compensation for all reasonable costs incurred in prosecuting this act. That makes the attorneys, it's a rainmaker, we call it, for them. The attorney's fees owed to outside counsel are fair, reasonable, and appropriate under Minnesota law. The court retains jurisdiction over the parties, and the abatement proceeds to and the extent allowed by law as a result of the final judgment. The court will enter such further orders pertaining to the implementation of the abatement program as necessary in the action. It is so ordered on the 26th day of August 2019, and this is Thad Balkman, the district judge there in Cleveland County. So this basically closed out the opioid trial, and we'll see in other states, counties, etc., what will actually happen in those jurisdictions. and how they will fashion their lawsuits. Now, the nuisance law is different in other places, and I think we made that clear there. Some of them are limited, but not in Oklahoma. And as we related earlier, you have to look at the content of the state, that it was populous in the beginning and recognized as progressive. It was not always a right-wing situation, period. Now this is from the Washington Post. Do a little recap here. With more than 40 states lined to pursue similar claims against the pharmaceutical industry, and the plaintiffs' attorneys around the country cheered it, no doubt about that, and would be a model for enormous federal lawsuits brought by over 2,000 counties, cities, Aboriginal or Native American tribes, and others scheduled to begin in Cleveland. So these places will be in various venues throughout the American nation. So Elizabeth Brunch, a professor of law at the University of Georgia Law School, who follows the cases, said in email other states will almost certainly adopt some of Oklahoma's strategies, for instance, arguing that Johnson's culpability because of its two subsidiaries that provided, refined, and supplied the ingredients. But by state laws differing, it's unclear whether the plaintiffs would be successful at proving the company harmed residents. In a federal way, I see it as more productive there. More than 6,000 Oklahomans had died from painkiller overdose. Yeah. So, in other words, this was ideally set up for Oklahoma law, and that it was a nuisance, a tort remedy, basically what's called an attractive nuisance that is sometimes used. That's usually when something is on, say, a sidewalk, or something that causes a pain and harm to people. A little bit different there and how the abatement is done. Nonetheless, on the 27th of August 2019, this is Boston Red from the Jerry Pippin broadcast booth. Jerry is smiling down on us. And the episode is the state of Oklahoma versus Johnson&Johnson. Good day, and we will see you soon. Incidentally, you can find us on various networks. iHeartRadio will be there. We'll be on Stitcher, Streaker, Twitter, Facebook. And if you find us on entertainment, we should be on the news. We'll have to change that each time for some very, very strange thing. We're also on Google Podcasts. We're on some of these smart speakers. We advise you with the smart speakers, Alexa, etc., to handle with care. Unplug the damn things when you're not using them. But you can say Boston Red there. We don't advise that. And the RSS feed, that's a traditional way of finding us, and hopefully that is working out.
This is Sarah Guthrie, granddaughter of Woody Guthrie.
As I was walking that ribbon of highway, I saw above me that endless skyway. I saw below me that golden valley. This land was made for you and me. Let's sing it together. This land is your land. This land is my land. From California to the New York Island, from the Redwood Forest to the Gulf Stream waters. This land was made for you and me. Oh, I've roamed and rambled, and I follow my footsteps through the sparkling sands of her diamond deserts, and all around me a voice was sounding. This land was made for you and me. All at once, this land is your land. This land is mine. To the New York Island, from the Redwood Forest to the Gulf a great high wall there that tried to stop